Ms Legalista here, aka Attorney Sheila. I have talked about this before. I'm probably going to get in trouble in this video. I'm going to try not to, though.
Yeah.
Some of you may remember back when I want to call them the Seven Dwarfs. It feels like there was some other media group that called them that. I don't know if you remember back when all the hearings were going on with the tobacco companies, and then they had this ultimate settlement out there that took place. Why? Because of things like Joe Camel and this sort of idea that the cigarette companies knew that nicotine was addictive, and they were setting something up so that they could get their market in place, cement that relationship at a younger age, and then know that you have customers for life. Like I said, I could be getting into a lot of trouble with this one. But here's what's going on. Social media. Social media. Now, I did a video a while back. None of you were interested in my video, but I think I've decided that I'm going to continue to talk about this anyway. Yes, the addiction of social media. We don't have a conversation about that. I think maybe we should have a conversation about that. Maybe not. Some people say that you can take responsibility. You can turn your phone off. You can delete these apps from your phone. You don't have to use them. You don't have to engage in any of this. Nobody's making you spend all of your time scrolling. A lot of times, what people don't understand is yes, there are two parties to this. And part of this is yes, I have control. I can choose to put this down, I can choose to turn this off. The other side of that equation is knowing that there is a party that is out there who has said, you know what? We're going to put some things in place that make it difficult for you to put it down, that make it harder for you to put it down. We are going to do our very best to make sure that you never put it down. In fact, we want you to get up first thing in the morning and look. We want it to be the last thing you see when you go to bed at night. So some people are saying that this is not fair, that if everything were equal, throw fairness out the window for a second, because some people will say, well, life's not fair. If everything were equal, then I would feel okay and I could easily walk away from some of these social media apps here on my phone or that I use on my computer. If everything were equal, the argument here is it's not. It's not equal. At least that is what's going on in a number of lawsuits across the country that are alleging that these social media platforms are addictive and that they are targeting our children early, that they have made these apps have certain features that it's more likely for our young children to get on them and not want to get off. So I want to pop over to this recent decision because, hey, there's also a law out there that says, hey, whatever the social media platforms put out there, other people put content up there. That content is not my fault. I don't have anything to do with that content. Let's see if I can scroll down, actually find. Let me fix my tabs here so that I'm not running all over the place. Let's get my tabs here. Let's scroll up so you can see the very top of what's going on. This was just filed today. I'm early. Today. United States District Court, Northern District of California, because you know, California is where a lot of these are located. This is in regards to social media, adolescent addiction, personal injury, products liability litigation. They are saying there is something wrong with your product. So, this order from the court grants in part and denies in part defendant's motion to dismiss. So, hey, YouTube and Snapchat and TikTok and Meta, which owns Facebook and Instagram, have said, we want this case dismissed. And they have their reasonings behind that. And I'm actually going to break this video up into several videos because I want to talk about a lot of the issues that are being brought up in this, in not just this particular document here, this order, but just some of the issues that we're seeing out play out in the real world in terms of people doing things just because of social media. Now, let's backtrack for a second. Would they still do those things if social media were not there? I don't think they do some of these things. I think they do other things that might be very similar to the personality type that they already have, but social media has just allowed them to do it in a different sort of way. Well, let's take a look at this lawsuit. And I'm going to scroll down. I'm going to first give you this background. And then there's a piece I want to talk about before I get into all of these different features that they say that it has. This order addresses the first wave. Okay, the fact that they call this a wave, I told you these were going on across the country. Addresses the first wave of legal arguments stemming from the filing on behalf of children and adolescents of hundreds of individual cases across the United States against 5 companies operating some of the world's most used social media platforms: Meta's Facebook and Instagram, Google's YouTube, ByteDance's TikTok, and Snapchat. Now, they've got a number 1 there for footnote. And what I would love to see is if they're giving us some information on how big they are. No, they aren't. They're basically just talking about ownership. Ownership. That's all they're talking about. Notably, this multi-district litigation, MDL, encompasses, in addition to individual suits, over 140 actions brought on behalf of school districts and actions filed jointly by over 30 state attorneys general. Now, you remember they're like 50 states, right? While plaintiff's complaint asserts 18 claims against defendants, this order addresses only defendants' motions to dismiss the individual plaintiffs' 5 priority claims. So we've got 5 priority claims that we're going to be looking at. For the reasons set forth in this order, based on a careful review of the pleadings and the briefings submitted by the parties, as well as oral argument heard on October 27, 2023, the court grants in part and denies in part the motions to dismiss plaintiffs' products liability claim, and finds that Section 230 and the First Amendment do not bar plaintiffs' negligence per se claim. Now, Section 230 has been thought of as this safe harbor provision. I can have a platform out there, and whatever's going on, whatever people use it for, that's on them. It's not on me. I just created the platform. That's been this argument for a really long time. And every time something major happens, Congress says, we're going to go back and look at Section 230, the safe harbor provision. And then, there's some new issue that takes priority over that. All right, so it says Section 230 and the First Amendment do not bar plaintiffs' negligence per se claim. By way of summary, the court finds that the parties' all or nothing approach to the motions to dismiss does not sufficiently address the complexity of the issues facing this litigation. They're saying this is complex and we need to go into some detail here. The court's really saying here, okay, there's not going to be this all or nothing approach to this dismissal. Defendants are saying, hey, we're protected under Section 230, safe harbor provision, okay, can't come after us. If other people posted stuff that people got addicted to, that's not our fault. If women like to spend hours at a time looking at video after video after video of people doing their hair and putting on makeup and doing get ready with me's, that's not my fault. Okay. I just put the platform out there. That's what defendants are saying. I just put the platform out there. If people got addicted because they were so into this influencer, well, that's on them. I just put the platform out there. And Section 230 allows them to sort of say that, right? Plaintiffs are saying, there's a whole lot more to this because in some instances, these are children, their minds are impressionable, and we're going to present scientific data to back that up. And we're going to talk about what you did. You didn't just put a social media platform out there. You had an algorithm. You put features out there to make sure that these young, impressionable minds, once they came, they stayed and they stayed and they stayed. And then it started impacting their thinking and their behaviors. So, yes, you are responsible. So the court is saying, this is complex and we need to talk about this. So I'm not just going to throw it out like defendants are asking, and I'm not just going to believe every and all that you're saying, plaintiffs. So dismissed in part, granted in part also. As you can see, I'm into this. I'm into this. Nobody else is probably going to be into this but me. I'm going to be into this all by myself. Okay. The next thing we're going to go over is the procedural background to just a little bit, because this can sort of get funky. And then we're going to go over some relevant facts alleged. And then I'm going to skip the defect allegations for now, because that's when we start to talk about the product liability. I'm going to save that for a whole nother video, because I want to spend time really talking about it, really truly talking about it, maybe even talking about it from a personal perspective. So let me back up here for just a second and see if I can find where I was when we're talking about procedural background. Okay, so look at this. The master amended complaint was nearly 300 pages long. 300 pages. You guys, I think I need to go back and just start doing videos on this. Think about how many people are on social media all day long, how much is being uploaded, how much is being shared, how people are connecting. This, I think, is one of the biggest lawsuits that this country is going to be facing. I think it's right up there with the tobacco lawsuit. Okay. Y'all don't believe me, but I think that's how important this is. Plaintiff's master amended complaint is nearly 300 pages long, asserting 18 claims brought under various state laws on behalf of hundreds of plaintiffs. So here are the 5 priority claims. Remember, I said that. Claim 1, strict products liability, design defect, New York. Claim 2, strict products liability, failure to warn, New York. Claim 3, product-based negligent design defect, Georgia. Claim 4, product-based negligent failure to warn, Georgia. Claim 5, negligence per se, Oregon. Defendants filed 2 separate consolidated motions in response to the MAC. I'm going to call it the MAC, Master Amended Complaint. The first, hereinafter referred to MTD1, addressed whether plaintiffs have legally stated each of the 5 priority claims. The second focused on the immunity and protections under Section 230 and the First Amendment. I'm going to have to do a separate video on that, or insert that in here somewhere. Here's Section 230. Okay, there you have that. Relevant facts alleged. Okay, this is the last piece I want to go over in this video. The court focuses on the allegations relevant to the pending motions. Thus, the master amended complaint alleges as follows. Defendants are companies that own and operate social media platforms. And then there's this piece right here where Snap says in a footnote, okay, Snap's argument that Snapchat is not a social media platform and is instead a camera application failed to persuade. Like one court said, you're more than just a camera. Okay. Defendants are companies that own and operate social media platforms. Each, let's get past those footnotes. Each platform allows users to create profiles and to share content. This is the social media connection part here. Okay, because otherwise, if you were just putting stuff out there, then it's just out there, right? You could be an encyclopedia. And to share content, including messages, videos, and photos. Significantly, these platforms are more than mere message boards or search engines. In addition to enabling users to look for content or to send content to other specific users, in many instances, the platforms determine what I say here. The platforms determine, this is what the court is saying. The platforms determine when and to whom certain content is shown. All that stuff that pops up in your feed, that's not the people you're connected with, all that suggested content based on an algorithm that the social media platform owns and puts out there. Yep. So I don't know if you can say I've been hands off court, and to whom certain content is shown. As noted, the platforms here at issue are Facebook and Instagram, both operated by Meta, Snapchat, TikTok, and YouTube. Use of these platforms is generally free. Why do you think that is? Defendants make money primarily by selling advertising space. Marketers covet such space because defendants pose vast data about users. This enables them to target advertisement to specific audiences. Given this business model, profits from these platforms are highly dependent on the number of users, the amount of time each user spends on the platform, and the amount of information a user provides directly or indirectly to the platform about themselves. Now, there are the defect allegations below, but let me hit on the irony here. Think about the irony of an attorney reading a lawsuit on social media about why social media is addictive. All right, that's the irony there. So, first video one, next video, we are going to get into going through all of these defects that make up the product liability. We're going to discuss those in detail and break down some of these features that they are saying is what has made these platforms addictive. Go ahead and give the video a thumbs up. Don't forget to subscribe. Don't forget to hit the notification bell. Let me know in the comments which of these platforms you use. Do you have kids? Do you let your kids use these platforms? Do you monitor their use? Do you take their cell phones, their computers? Do you know what's going on? All right, peace.